All right, welcome everyone. This is Bob Tankle, and this is the first of what I hope is a continuing series of brief 20-minute meetings once a week to talk about current issues in community association law and take questions from people who attend. So I don't think that anyone has joined us yet. So let me start out by saying that I appreciate you tuning in, and I guess the vast majority of you will be seeing this on video. Behind me is my curated collection of Florida Gator National Championship and other trophies. And what I'd like to talk about today is a little bit about matters relating to the legislature, the legislative session, and related issues. So what I'd like to talk about is the absolute failure of the legislature to pay attention to association related issues. I think we live in a failed state, as I've said to my colleagues, and it's just incredible that, for example, Champlain Towers collapsed and the legislature couldn't see its way to passing a law that takes into account all of the various parties' interests. The word is called stakeholder in Tallahassee. Of course, I have the idea that it's a bunch of people holding an STAKE and are facing each other and ready to jab each other with it because you've got different interest groups. So this is a review of what happened in Tallahassee, which is not much. The good news is, at the same time, the legislature also had a bill that would have limited construction defect claims to 5 years from an absolute maximum of 5 years. It's called the statute of repose. And the statute of repose is different than the statute of limitations because the statute of repose is a hard stop to anything related to the issue which involves a statute of repose. So that failed, but there was no law passed. That law failed, and the law requiring inspections every so many years failed as well. What I'd like to do is talk about a couple of issues related to this, though, is that the banking industry has convinced boards that they can only reserve and keep reserves in what are called certificates of deposit. And that's not true. There's nothing either in the Condominium Act or the Homeowners Association law that says that you can only keep CDs. So do the math. If you are keeping reserves in an account that pays 1.15% and you end up with a major repair, they will gladly lend you money at prime rate plus 3 points or 300 basis points, which I think is now about 5.25. So that is a wonderful spread between cost of funds and what they lend it to you on. And I think one thing that boards need to wake up to is the fact that you have a duty to your members to maintain, repair, and replace the common elements. You have the duty to attend to those capital expenditures needed for maintenance, and that you have to set aside monies for those matters, because if you don't, you'll end up like the client I just spoke to, who's looking at a $2,000 per unit special assessment at a minimum for replacement of the boards that support the individual electric meters, which are in short supply, and there's only one supplier, and they have no reserves. So there are ways to levy assessments over time, but there are vital ways in which you construct the assessment so that when the time comes, if there is an owner who doesn't pay, first of all, you adopt a zero tolerance rule. Second, you adopt an assessment not all at once, but over time, which is something we've done, because you always have to think about the fact that there may be a mortgage foreclosure in the background that is coming. And rest assured, there are a lot of mortgage foreclosures coming. And if you've got people who aren't paying, you need to make them pay. You're not a mom and pop candy store or newsstand. The client we just spoke with, it's very modest, 104 units. They're worth about 140. Well, I don't know what they're worth, but they're selling for $140,000. And do the math. I think if I'm right, that's a $14 million physical plant. And just like our country, you can't have second world infrastructure. But unlike our country, you can't just borrow and pretend and kick that can down the road until you've got 20 trillion in national debt. You have to have a plan to pay it back. And as a result, you really need to understand that your principal goal and your principal obligation is to the members as a whole. You need to get rid of the word compassion in your vocabulary, because compassion is sending money to people in Ukraine who've been displaced or are refugees. And compassion is not allowing your next door neighbor not to pay because they say, I'm on a fixed income. It's unfortunate, but you are not a charity. You are a community that needs to be maintained. And your obligation is no less serious to your corporation than any corporate director on any for-profit corporate board. And you have to fund ongoing capital expenditures and maintenance, really, and do so either in the budget or by special assessment. And you don't have to keep it in certificates of deposit. You can keep money as a prudent person in equities and other forms of investment, and just realize that over a 20-year period, no one has ever lost money in the stock market. Now, I'm not a stockbroker. I have no interest in this, but you have to understand as directors, no matter what the size of your community is, that you have to keep the community running and well-funded, because the issue of your finances is going to be a material issue with regard to whether units will sell in the future. And if you have books, your records show that there are no reserves, that's going to be factored into the price of the units. And as a result, I think that it's prudent that you take the time to talk to someone who can help you with investments and help to grow your reserves and maintain your property and keep it worth what it's worth. Let's also talk for a minute about some recent hot issues in association law. One of them is there is a big misconception about interviewing and talking to and getting information from prospective owners and tenants. In order to do so, you have to have a restriction that says you can, whether it's by rule or better in your documents. And the grounds upon which you can reject someone are really quite narrow. And as a result, a lot of communities, I believe, have a false impression as to what their powers are and what they can do as regards people who want to buy or lease within the community. You can have rules and you can have document restrictions, but fundamentally, if you interfere with a sale as the result of a defective rule, or if you interfere with the sale because a buyer or a tenant either won't come in for an interview or you don't have the proper basis for an interview, or as the result of an interview, you find out something about the occupant that is not restricted by your documents and you interfere with the sale, you're going to make your community subject to a potential claim for unlawful interference with the sale, in which case you have potential liability. Speaking of liability, it's very rare that you would have personal liability for anything you do, as long as you act as a reasonably prudent person under similar circumstances. That is your obligation under the law. You don't have to be a lawyer. You don't have to be a banker, a CPA, an engineer. The law specifically says that you can rely on people who you reasonably believe to have expertise in those areas. And as a result, unless you personally profit from decisions you make, or you make it by fraud or concealment, the fact that you make a bad decision does not mean that you are monetarily liable for a decision you make or fail to make. If you are smart, you have directors and officers liability insurance, or commonly called errors and omissions insurance. The shorthand for that is D&O or E&O insurance, and make sure that your agent has a broad policy that covers you not only for monetary damages, but for things like injunctive relief or alleged violations of civil rights laws like the Fair Housing Act. And they will, at a minimum, provide a defense, because in most lawsuits I've been involved with over my 40-year career, the vast majority of these cases settle with the board taking corrective action and everyone bears their own attorney fees. It's quite rare that there are monetary damages awarded. And if the suit is not for money damages, but instead it's for a violation of the Fair Housing Act, for example, then it's not so, you're going to spend a lot more on legal fees defending it than you will on paying damages. That's very important. That's not addressed by the law. And that is something that you should work on with your insurance agent, because I wouldn't serve on a board if there wasn't a broad form of directors and officers liability insurance, and it's not that expensive. Let me move on to a different topic. The issue of estoppel certificates. What in connection with the sale or refinance of a unit, whether it's a lot or a condo unit, the association's required to provide what's called an estoppel certificate. And most of the time that's done through management companies. What I've found is that a lot of companies are adding what might be called junk fees to these certificates, whether it's on the buyer's side, which is, for example, a transfer fee that's not allowed by law, or on the seller's side, which is maybe a convenience fee, which is in excess of what's allowed, the $250 for the initial estoppel certificate, or the rush, which is another 100 or another 150 if they're delinquent. But a convenience fee to offset the credit card charges, if it exceeds $250, is not legal. And your association and management have potential liability for that. So that is an important issue. And you should make sure that you know what your board is doing if you issue these documents themselves, or you have a management company that does so, because that is a fertile ground for lawyers, let's just say for plaintiffs' lawyers. So that relates to that issue. As far as being aware of some amendments that you should consider for your documents are, for example, the legislature, as of July 1st of last year, passed a law that says you cannot change the address of an owner without their consent. Now, what did the legislature not do? The legislature did not pass a law which says that you are entitled to rely on a certain address as the address of the owner unless they change it. For example, it would have been very easy for the legislature to pass a law that says there is a rebuttable presumption that the address of all owners is the address on the face of the recorded deed. And it's up to the owner to tell you, no, I want my mail going somewhere else. At the present time, there's no law which says what the address of an owner is. Some people get it off, some boards and managers get it off the deed, some get it off the property appraiser. One thing's for sure, if you have an address and it works, keep using it. If you have an address and you don't think it works, do not change the address. That is a violation of law. And there are a couple of foreclosures recently that we had to dismiss because the management company decided on their own to change the address of the owner. And that was after July 1st of last year. So where are we at? You need to look at your documents and consider some changes to tighten them up. And you need to operate in a proper, prudent, and professional fashion. And I promised that these weekly chats will be 20 minutes, and we're coming up on 20 minutes. So if there were questions, I'd take them. But let me address a couple other issues. Emails. Your board of directors is never obligated to answer an email, period, end of story. The only time you have to answer anybody is if they ask for access to inspect and copy the records, and if they if you're a condo, if you have a certified mail inquiry, you have to respond to that inquiry within a certain period of time. So that is the only time you have to do so. And we run into a lot of directors who are just exhausted with a torrent of emails from owners about whatever's on their mind. And we tell our directors, you don't have to answer them. Now, is it a good idea politically to answer questions or inquiries made by concerned owners who want information? Sure, that's not a problem. But there are some owners who will email you to death. Well, hopefully not, but they'll send incessant amounts of emails and you don't have to answer them. And what you can do is say something like in response, I'm not required to answer your emails, therefore I'm not going to respond to any of your emails in the future. Thank you very much. So I think I've hit my 10-minute limit. So I'm going to bid you adieu, and I will pick you up on the flip-flop, as they say, next Thursday at 12:20, same time, same place, maybe different background. Thanks, and be careful out there. Bye.